and it'll take you right to it.
Another way to go, yeah. Okay.
Now, I should say, 555 doesn't answer all the questions.
Yes.
Because it is addressed to married couples. So it says things in the publication like, under most community property states, the spouses can agree that their community income will instead be separate.
Yes.
And we will honor that agreement for tax purposes. What they don't tell you or don't address is the fact that if you are not married and you enter into such an agreement, some gift tax issues might arise. So we can't just suddenly agree that income from the past that was
Right.
community will be my separate income, or that my separate income from the past will now be treated as community. It might be valid under state law to change the nature of the property, but the IRS is not going to recognize. I mean, they'll recognize it, but they'll call it a gift.
Yeah. So, in other words, this isn't something that you can do sort of willy-nilly according to your whim.
No. Well,
And-
nobody can do it willy-nilly.
Yeah.
It requires going to a lawyer to enter into a separate property agreement or
Yes.
a post-nuptial agreement, and there are very strict rules about when those agreements are valid.
So this is, it's really a very similar thing to what you have for a married couple.
Yes.
And so we say each of you should probably have your own lawyer.
And that is exactly right.
And all these other
The
technicalities.
lawyer
So-
employment
so
requirements,
be
yes.
very careful if you want to get involved in this. And it means, though, that you can't just switch, very easily from year to year.
Right. That is right.
Okay. So why don't you talk a little bit about, they also addressed in one of these rulings some gift tax
Yes, and I
consequences.
think that's very important. In the private letter ruling, the attorney representing the two registered domestic partners there specifically asked whether or not the creation of community property from community earnings would be treated as a taxable gift. I mean, if you imagine it, you've got one partner earning $1 million, the other partner earning nothing, and every year the other partner's kind of acquiring $500,000 in assets that result from the $1 million of the income stream. How does he get that money vested in him? It would be a gift in any other situation. But under Poe versus Seaborn, it was not a transfer from the earner to the other partner. It was the non-earner's property from the get-go. As a result, the IRS concluded it is not a gift.
Right.
And that is something we've been debating since 2005 when the community property rules were first adopted. It is quite a relief to have some guidance. Even though it's only a private letter ruling, it's based on the application of Poe versus Seaborn to the fact situation. So no taxable gift upon the creation of community property.
Okay. What about e-filing?
That, I don't know the answer to that yet, and I do not think the IRS knows the answer to that yet. One of the problems, of course, is that I do my own taxes, and I use a tax preparation service to do that. But it's not easy to build in a spreadsheet unless it's a form.
Right.
And so there is no required form for the splitting of community income. There's just this informal spreadsheet that you need to attach to the tax return when you send it in. I don't think you can do that e-filing unless the IRS makes some changes. Now, I'm working with an ABA committee to try to come up with some recommendations based on what we see as issues, and e-filing is one of the issues. Maybe if they made a slight change to the 1040, maybe if you could check someplace to let the computer who reads the form know that you're filing single but you're splitting community property, and there was a place to put the social security number of your partner. We don't have that for registered domestic partners. The forms don't conform to our real situation. So e-filing may not be possible.
Yeah. And what I've suggested in some cases, because I run into some of these problems related to employee stock options, particularly related to elections like 83B elections.
Yes.
So you can't just send that in with your e-file form right now. They are talking about trying to allow eventually for you to scan something and send it in, which would be a nice way to go. To send, you can send a PDF, but for the time being, what I've been telling people is send in a 1040X with the documents that you can't send with your e-file. I mean, that's just
That's interesting.
a way
yes.
to maybe do it.
Well, the
Okay.
IRS knows about this, and I think they're looking at it. It's a problem right now, but maybe by tax filing season it'll be settled.
It would be nice if they would develop a form.
Right,
I
right.
think we talked about
Or
this.
at least tell us things. I mean, what everyone is assuming is that if I have $100,000 of earnings and I have a W-2 to that effect, I need to put that on line 7 on the 1040 because the computer that reads it's going to match my W-2 income up with my Social Security number.
So you
But
subtract it down
I
below.
subtract it on line 21, the
This is-
miscellaneous
or other
income.
income, yeah.
So I subtract it there and I add it in there for my partner.
Okay. Now, time is going here. Let's talk for a few minutes about a few problems that are remaining.
Okay?
So, how about dissolutions?
Dissolutions and property divisions.
Yeah.
Now, the ruling could help us in that regard. It does say it's community property. So if your property division is merely a division of what is community property, that is not a taxable event. But spouses, of course, have the benefit of being able to trade separate property for community property, and any transfers they make are not taxable at divorce because there is a statute, Section 1041, that applies to them. That can't be applied to registered domestic partners or same-sex spouses so long as DOMA is on the books. But the community property rule does help us there. Then there's alimony.
Yes.
We don't know how alimony is treated when it's a non-spouse, a registered domestic partner, or a same-sex spouse who's paying it. Clearly, there's no deduction because the deduction allows it to spouses.
Right.
That's the word spouse, DOMA applies.
Right.
The question is, absent a statute, is it possible that the receipt of alimony is not income? And we do have an old 1917 Supreme Court case, Gould v. Gould, before we had any statutes on the matter, that said alimony received by the wife after divorce is not income to her.
Okay.
By analogy, you might be able to use that, but it sure would be nice to have statutes that clarify all of these things.
Yeah. How about employer medical?
Oh, now this is another problem because if a registered domestic partner is employed and the employer is covering that registered domestic partner and her partner, the value of the benefit to the partner is sometimes taxed and sometimes not. It's taxed unless you can show that the non-earning partner was a dependent. And to be a dependent of the earner would have to provide over 50% of the support for the partner.
Right.
Now that we have community splitting,
Right.
all of the earnings of the earner, 50% of those are going to be attributable to the non-earner. So it's going to be virtually impossible to prove that you are supporting your partner if she's already credited with 50% of your income.
Okay. Well, we're about out of time here. So do you have maybe a final thought before we wind it up?
I do. A lot of people are worried about these rulings because they think it's a hassle to have to do these forms without much guidance. But on balance, I think this is a very positive step for the gay and lesbian community. Before this ruling, we had uncertainty. We didn't know what the rules would be that would be applied to us. Now that we know that Poe versus Seaborn, which has been on the books since 1930, and all of the rules that flow from that apply to our community property, we have at least an amount of certainty.
Okay, well, about out of time there. Professor Kane, thanks so much
Thank
for joining
you.
me again, and we'll watch for more developments here.
I'm sure there will be
because
some.
We have we have a big community here in San Francisco and Santa Clara County, in particular, that are interested and across the country. So, anyway, folks, we'll try to keep you informed the best that we can in this area, and we hope that you can join us next time on Financial Insider Weekly.